Okay, we're just going to wait 30 seconds to allow people to enter from the waiting room. Maybe a minute. I'll just ask everybody to mute, please. Okay, the number seems to have stabilized. So let me start by welcoming everybody to the very first Gordon Henderson Chair on Business and Human Rights speaker series. Thank you very much for coming. I know everybody is busy at this time of year, and it's great to have you all with us. I'd like to just quickly also thank the Human Rights Research and Education Center and Caroline Fauché, Viviana Fernandez for making this possible, and also three of my research assistants, Rochelle Demers, Bahar Jafari, and Jake Norris. We're here today to talk about the issue of mandatory human rights due diligence legislation. That is legislation that will require companies to identify, assess, and prevent potential human rights violations and cease acts that violate human rights and that are associated with their business activity on an ongoing basis. Now, Canada's extractive sector has been in the global spotlight, particularly since 1998, when Talisman Energy was implicated in grave violations of human rights that were being perpetrated in what is now South Sudan in the oil fields. And since that time, there have been an increasing number of cases filed against Canadian extractive companies in Canadian courts, calls from domestic and international bodies for Canada to regulate its extractive industry, and persistent civil society campaigns. However, unlike its European counterparts, which are starting to introduce legislation that would mandate human rights due diligence, the Canadian government has only taken halting and inadequate steps towards establishing any form of effective oversight, accountability measures, or remedial mechanisms that would rein in its extractive sector and provide effective oversight and remedies. Right now, there's a private members bill that has been tabled that, if enacted, would implement what the Canadian Network on Corporate Accountability's model human rights due diligence legislation in that sense, and that's Bill 262. There's also a bill before Parliament aimed at tackling forced and child labor in company supply chains. That's a Senate bill that has now moved to the House of Commons and is currently in its second readings. So what can Canada learn from developments in Europe and also from the Inter-American Human Rights System, the bodies of which have called on Canada to regulate its extractive companies? I have a great group of panelists today who are going to help us answer some of these questions. First of all, Emily Dwyer, who's a lawyer, a law degree from Dalhousie, and is the coordinator of the Canadian Network on Corporate Accountability, and has been in that position since 2012. She has decades of experience in human rights activism. Prior to joining the CNCA, she worked as the program officer for Latin America for Lawyers Without Borders Canada, and as coordinator for the Human Rights Accompaniment Program for the Maritimes Guatemala Breaking the Silence Network, among other things. And she has been working at the forefront of the campaigns to get Canada to regulate its extractive companies operating abroad. I also have Daniel Sequeira, who has a law degree from the Federal University of Minas Gerais and an LLB also from the Pontifical Catholic University of Minas Gerais in Brazil, as well as an LLM in International Legal Studies from Georgetown and an MSc in the Global Rule of Law from Genoa. He is the director of the Human Rights and Natural Resources Program at the Due Process of Law Foundation, which is an NGO based in Washington, whose mandate is to strengthen the rule of law in Latin America through the use of international human rights standards and complaint mechanisms. And before he was at DPLF, he was a human rights specialist at the Inter-American Commission on Human Rights. We also have Marcus Krajewski, who is a university professor at the University of Erlangen-Nuremberg and holds the chair in public law and public international law. He is the chairperson of the Interdisciplinary Research Center for Human Rights at the university, and he also chairs the Board of Trustees of the German Institute for Human Rights, as well as being Secretary General of the German branch of the International Law Association. He advises international governmental and non-governmental organizations on European and international economic law and has acted as a consultant on different development cooperation projects. And his research focuses on international economic law, human rights, European external relations, and the law of public services. And he's published widely on these issues. Our final panelist is Robert McCorquodale, who is Professor of International Law and Human Rights at the School of Law of the University of Nottingham. He's also director of a consultancy he's founded called Inclusive Law and a barrister at the Brick Court Chambers in London. He has acted and is acting as an independent special advisor to the United Nations Intergovernmental Working Group on Business and Human Rights Treaty, on the Business and Human Rights Treaty, and he is the co-author of the report on supply chain due diligence, which led to the European Commission's decision to draft a proposal on human rights due diligence. He has also been nominated as a member of the UN Working Group on Business and Human Rights, which is very exciting. And he's published widely in international law, international human rights law, and business and human rights. So let's start our discussion by setting the context. So I'm going to turn first to Emily and then to Daniel. Emily, I'll just ask you to briefly set out, what's been going on in Canada, this two-decade-long campaign to get the government to regulate Canadian extractive companies, and what has Canada done in response in terms of governance and remedies?
Great. No small order in a 5-minute time slot, but I'll do my best. I have my timer on, so you might hear a beep at the end just to cut me off because I could talk forever. So the Canadian Network on Corporate Accountability now has 40 member organizations from across Canadian civil society, including international development, human rights, environmental and faith-based organizations, and labor unions. We were formed in 2005 when Canada's International Human Rights Subcommittee was studying the harms linked to Canadian mining in the Philippines. And that subcommittee recommended that Canada needed to develop laws to hold Canadian companies to account for the harm they do overseas. And many of the recommendations that they made remain true today. Following that, there was a series of roundtables where the CNCA became a bit kind of more solidified as a coalition. And those roundtables included government agencies, industry associations, civil society, and academics who were studying the issue of mining in developing countries. They issued a series of consensus recommendations, and many of those recommendations, again, remain unfulfilled today. So in a snapshot of what we have been doing in the last, that last 20-year period, is that civil society has worked to educate Canadian decision makers about the harms linked to Canadian companies operating overseas and the possible solutions that we could take here in Canada, including best practices from other areas. We campaigned in 2009 and for longer than that for a law that would condition Canadian government support to mining companies to them respecting human rights and the environment. That law, Bill C-300, was narrowly defeated after the mining industry campaigned against it. Mm-hmm. We have campaigned since 2012 for an independent ombudsperson with real powers to investigate, including the power to compel documents and testimony. That campaign has had both major wins and major blows, again, after sustained mining industry campaigning against it. But that campaign, despite the fact that we still don't have an independent ombudsperson with powers to investigate, it has had other impacts, including opening political space in Canada to talk about more comprehensive reforms, such as our current main campaign focus, which is on mandatory human rights and environmental due diligence legislation. So what's the impact of all those that campaigning? How has that changed what the context in Canada? You could look at that as a glass half full, glass half empty. Canadian government still relies almost exclusively on voluntary approaches. We have two non-judicial grievance mechanisms, the National Contact Point and the Canadian Ombudsperson for Responsible Enterprise. They're both primarily based on offering mediation and on encouraging companies to voluntarily do the right thing. That's what the Responsible Business Conduct Unit in Global Affairs Canada and our Responsible Business Conduct Strategy is focused on, just convincing companies to voluntarily respect rights in the environment. and despite the fact that that hasn't worked. But there also has been a shift. Civil society is much more knowledgeable about how lawmaking works. And we're much more effective in the kinds of proposals we're putting forward and how we're pushing for them. Our movement is growing. We've doubled our membership since 2012. And despite the pandemic, despite these losses, we continue to be strong. And also, there's been a shift in the government's narrative. We're no longer at the starting point of saying, is there harm? Which is where we were for 15 years, where you would first have to say, are companies even doing bad things overseas? Now we've moved beyond that, and we're actually talking about what the law reforms are needed here. We have an office that's called an ombudsperson. It doesn't have the mandate or powers that it needs, but we've shifted from needing to call for the creation of that office to saying, now that office exists, you need to give it the power to actually be effective that you already promised would happen. And what I talked about at the beginning too was that we've also shifted the political space so that we can talk about having a comprehensive law that requires companies to prevent harm, to do due diligence, and gives access to Canadian courts for harms throughout a company's supply chain. That's something that we could not have talked to Canadian decision makers or media about 10 or even 5 years ago. And now we can seriously be having conversations about it. So I'll pass that along to you.
Thank you very much, Emily, for not only giving us some great background, but also doing it so succinctly. That was really helpful. Thank you. I'm going to move to Daniel now, and I'll just ask you, Canadian companies operate across the globe, but there's a significant Canadian extractive company presence in Latin America. And I just wondered if you could describe the impact of Canadian extractives in Latin America and the calls from and hearings that have been held by the Human Rights Commission that are related to Canadian extractive activity.
Thank you very much. Penelope, I'll do my best to in a snapshot, to address this complex issue. It's important to give also a background on the relation between Canada and the inter-American human rights system. Canada has been a very new player, I would say, at the OAS. It has ratified the OAS Charter in 1990, one of the newest members of the organization. And the diplomatic relation between or among Canada and also the Latin American countries is much newer than the United States itself. Nevertheless, the impact of the Canadian mining activities in Latin America has been reported in several documents and by the Inter-American Human Rights Commission in the past, I would say, 5 years, mostly. Canada has had a very important role supporting the Inter-American Commission on Human Rights. It has backed the commission when it was attacked by, I would say, demagogue or populist governments throughout the past 10 years, at least. But nevertheless, Canada has not ratified a single instrument at the Inter-American Human Rights System, only the OAS Charter and the American Declaration on the Rights and Duties of Man. Although the human rights situations in Canada is not as complex as in other Latin American countries, or I would say even compared to the Caribbean countries, The Inter-American Commission has received a lot of hearings requests to address the impact of the Canadian mining activities in Latin America. As you know, Canada is a mining juggernaut in Latin America. It's known for the support it has given to democracy and also to human rights in the region, but also for the killing of environmental defenders such as Mariana Barca in Mexico, and also several very, I would say, conflictive process in which communities reject the presence of large-scale mining activities, most of them run by big Canadian companies. And in this vein, the Inter-American Commission has held at least 4 hearings. In many of them, my organization, Due Process of Law Foundation, participated in. And in every single hearing, the Canadian government would say, as Emily explained, that they focus on self-regulatory mechanisms and voluntary principles that should run the company's decision. It's quite uncommon to see the government of Canada in this kind of forum saying that, well, yeah, we do commit to move forward with the adoption of a mandatory law, for instance, on due diligence and human rights. And in 2018, the Inter-American Commission on Human Rights had a hearing in which Canada announced that they would approve soon the Ombudsperson office to address the violations committed abroad by Canadian companies, especially mining companies, also from other sectors. And in this occasion, the Inter-American Commission issued a press release praising this decision. But in the report published in 2019, the Commission pinpointed that the civil society organizations in Canada quit the board of supervision of this organ, and also highlight that it does not meet a good governance policy for addressing the violations that's going on, mainly coming from Canadian mining companies. In a brief, the Commission is concerned that the promise of an ombudsperson did not meet all everything that the Canadian government has addressed in these hearings. And also in other recent reports, the Inter-American Commission has addressed the ETOs, the extraterritorial obligation. I would say that the main reasons for that was the advocacy of Canadian, also Latin American organizations addressing the role of Canada in Latin America through its mining companies. The Inter-American Commission up until 2018, I would say, had very few standards on this issue. And now it has at least 2 thematic reports, one very comprehensive pronouncement in the last report on business and human rights, and also the Inter-American Court on Human Rights in advisory opinion number 23 issued in 2017, also addressed the ETO's obligation, many of them applicable very clearly to what Canadian companies are doing in the region. And one last piece of information, after each one of these 4 thematic hearings at the Inter-American Commission, the Commission published press releases asking Canada to adopt better mechanisms for access to justice, also supervision, and basically monitoring the role of its company operating in Latin America. There has been also other standards, general standards that's applicable to the situation of Canada, but I would say that Canada is basically the main reason why the Inter-American Commission on Human Rights has dealt with the ETO's agenda, and it certainly will keep doing that up until Canada has a better policy to address this problem. So I'll stay here to stick to my 5 minutes time. Thank you.
Thank you very much, Daniel, for providing that context. And that's very interesting that you said that Canada is actually the main reason why the Commission is engaged with this agenda on extraterritorial obligations of states in terms of regulating their companies. And I hope we can hear more about that a little bit later. Let's move over now to Europe, the discussion to Europe, and to Robert and Marcus. So Marcus, first of all, I wondered if you could briefly comment on the human rights due diligence developments or the laws that are being enacted by European states. And then Robert, I'll ask you to talk about the developments leading to the proposal for a directive of the European Commission.
Thank you very much. Yes, it's actually on the one side quite interesting, but also a little bit complicated, because I have the feeling every time you look at what is happening, not only the image is changing, but also the story that's being told is changing, because it depends a little bit on what you count as human rights due diligence laws. I mean, obviously we have some more narrow, some mandatory laws, but also we have a broader sort of context which we need to look at. And so I think, I mean, if I'm looking at a table which has been published by the European Coalition for Corporate Justice, which I always find is quite a useful summary. And in the table they list right now, they list 3 laws which are in force or coming into force, and then they list 3 proposals. But there are, of course, other elements or other developments in member states and also European states which are not member states of the European Union. I mean, it starts already with the question, what do you mean by European states? But anyway, I mean, I think the story that we would tell from Europe starts with the French duty of diligence, or the loi de vigilance. I think right now considered almost the mother of all laws, or at least the mother of all human rights due diligence laws, which was adopted and then entered into force in 2017. And then in some stories, you would hear that the next law was the Dutch child labor law of 2019. Interestingly, that has disappeared from the table I'm looking at right now. And so the next law in that table is the next 2 laws are the German and the Norwegian laws. So I guess I don't want to bore people with too many laws from different European countries. I guess the point I'm trying to make here is we have legal developments in many European states. There are proposals now for a more comprehensive due diligence law in the Netherlands, but there are also proposals in Austria and Belgium. There are developments in some other European member states. There has been, one has to say, a proposal in Switzerland, which was a proposal for a popular initiative, the Swiss Responsible Business Initiative, which was defeated at the level of sort of a constitutional amendment. And now they have a different law, which is much more narrow in context. And I guess if I were to summarize sort of the lessons to be drawn from all these developments, I think it's fair to say that in all of these cases, the development started with civil society campaigns. This was the case in France. It was certainly the case in Germany as well. To a large extent, also in Norway and in other parts, in other countries. These developments, these campaigns, I'm sorry, were then taken up by political actors, various political parties, depending obviously also on the constitutional systems of the states. And then what I think is interesting that we saw, and this is what I just heard from Emily as well, we've always seen initial opposition from business associations, which I find interesting, because apparently the organized sort of business community still seems to think that that's the best strategy, even though they succeeded, if you wish, in Switzerland. But again, there are different stories to be told as to why the proposal was actually defeated in Switzerland. But in most other countries, at the end of the day, there has been a law. And if I may at least summarize the experience from Germany, the impact the business associations had on the law was that it was a little bit narrower than originally proposed, but it was actually really the real result was that it was not a good law. It was a complicated law, a law with loopholes, a law which is confusing in certain parts, a law will may even have a negative effect on businesses. So this is what I still struggle with, is why are business associations still on this total opposition struggle, rather than realizing that they could contribute to some of these legal developments. There is, and I guess maybe Robert is going to talk about this as well, there are of course also already existing proposals at the EU, but since you asked me about member states or European states, I think that's the picture we're looking at. Thank you.
So I will just go on to talk about exactly that, what's happening at the broader European situation, and partly by the prompting of what was happening in France and a lot of very effective lobbying by civil society. The end result was that the European Commission, after quite a degree of reluctance, made clear that they were interested in considering this, and they gave 2 tenders for studies about what would this mean, one of which I was the co-author. I have to say, as an academic, it's very rare when you write a report and within 2 months the body, in this case the European Commission, agrees with your report and says it's going to act on it. Of course, that may sound great, but it was 2 years before they acted. And those 2 years was, as Marcus put so well, a lot of lobbying, particularly by companies. The irony in that was that our report did a very detailed analysis, surveys, discussions with companies, over 350 companies across Europe, and did also comparative research around European member states to came to the clear conclusion, the vast majority, like 70%, 75% of companies wanted clear law on this area. And that fits exactly with what Marcus is talking about, that when the companies are wanting this, the governments are still very nervous of doing anything. And often the trade union, if you like, or the trade association of the companies also refuses to engage in it when the companies themselves may want to. So it was quite a stark position. In addition, at the same time, the European Parliament pushed very hard, and they kept on pushing the Commission and they introduced their own proposal. And I think all of that kind of showed that there was this impetus. And I think the Commissioner himself was very keen on it. But once again, there was that pushback. And what we've got from the proposal, as we're going to talk in a moment, is quite a mixed draft, which I think is still quite a distance away. And then just why I'm talking about it, if it's okay, Marcus, just to say, we're talking about the proposal, as Marcus will say, but remembering it's probably going to be at least 2 years, is my guess, before it will get into any kind of final form, because the member states have to agree. So back to you, Marcus.
Thank you. Yeah, so I'm not sure how familiar people in the meeting are with the sort of the legislative process at the EU level. I mean, so it mirrors to a certain extent, of course, a legislative process in many national systems, but then again, in many respects, it doesn't. So it is a legislative process only starts once the Commission puts out a proposal. So many people in the call may know that there has been a proposal by Parliament, but that was just an opinion, a suggestion, a strong opinion, but it was not a parliamentary proposal. So the proposal that is on the table was adopted by the European Commission in February of this year, and that's when the legislative process starts. Now, the proposal has now been moved to Parliament and the Council, which is the two legislators. As far as I can see, in the Parliament, they've already assigned a rapporteur, the main committee already. There are co-reporting committees. So this is the normal legislative process. It will move into different stages of readings, both in the Parliament and in the Council. And then at the end, something that is now, I mean, obviously in Europe, a lot of people speak still French. It's called the trilogue. So basically when the three actors, the Commission, the Parliament, and the Council get together, and then behind closed doors, they will cook out a deal, and then we'll see what comes out of it. So I guess when we look at the Commission's proposal, when we look at the Parliament's proposal, we get a good idea of what two relevant actors want, but we have absolutely no idea what the Council, which is the representatives of the member states' governments, want. So that's still, I mean, also all the people that I talk to, and I guess, Robert, I don't know whether you have any more insights in this, but the Council is still the black box in this whole picture. So when we look at what is on the table, I think there are some very interesting aspects in there. And of course, I mean, I guess when we look at human rights due diligence legislation these days, there is sort of an emerging methodology of analyzing these laws, if I may say so. And one key question is, of course, which companies does this apply to? And so this is a directive, which I should have said this, I'm sorry, but a directive in European law is actually a legal instrument which needs to be implemented into domestic law. So we do have, and people in the call may have heard of the EU timber regulation and also of the EU conflicts mineral regulation. Those are laws which are directly enforceable and which are directly applicable at the EU level. But then there are other legal instruments, directives, which need to be transferred into member states' law. So even if this directive that is on the table right now will be adopted, it still needs to be incorporated, if you wish, into the laws of the, by then probably still 26 member states. So the proposal that is on the table right now applies to companies, or is supposed to apply to companies with more than 500 employees and a net worldwide turnover of more than 150 million euros in the last financial year. That's one. So all companies with more than 500 employees and an annual turnover of 150 million. And then there's a second group of companies, which I would say, broadly speaking, work in high risk areas. I mean, of course, mining would be one of them, but also agriculture is mentioned, and also textiles is mentioned. And for those companies working in these sectors, there's a lower threshold. It's a threshold of 250 employees and a net annual turnover of only 14 million. So I don't think we need to remember these dates, but it's, I think, compared to the French law and the German law, and it's certainly clear that the EU proposal would apply to a much larger group of companies. Yeah, so 500 employees or 250 employees in these high risk sectors. So that's actually very broad. What I consider, and I mean, this is maybe because we're basically also discussing maybe later lessons to be learned for Canada. What I think is interesting is that they apply to companies which are sort of incorporated in the EU or in EU member states, but it also applies to companies incorporated outside of the EU, as long as they operate on the European market, as long as they offer goods and services or have any form of business on the European market. And I find that is extremely important. And I'm just saying this because the German legislator made the mistake of not including non-German companies incorporated elsewhere. And so they would actually not be covered by the German law. That's maybe one aspect. And the second aspect is which human rights and environmental obligations are covered. And here I think it's interesting that the European proposal goes beyond covering human rights, but also covers climate change and environmental aspects. It does so in a rather complicated manner. I find maybe in the discussion, when we have time, we can, and people are interested, we can go into the details there. But it tries to it tries to address the problem that they don't want to say companies can violate human rights. So rather they say negative impacts on rights of persons protected under a list of conventions. So it's a rather complicated way, and I'm not sure whether that's the most appropriate way of regulating it, but I'll leave it at that.
I'll just perhaps follow up with a few comments on some of the problems with this, and I'll pass back to Marcus to pick up some other issues on scope, because I think that's quite an interesting element. So in a way, what's happened is there's been delight that we have at the European level a clear law on this area. The trouble is, it's a lot of mixtures of clarifications and uncertainties. And that's been a problem in terms of trying to work out the ways forward and how to improve it. For example, a core element, and I would say this as well in the Canadian example, should be consultation. Consultation should be very clear what consultation involves for companies. I mean, just to say the Canadian one is kind of hidden away in section 29. So it's not that upfront. And I think that's a concern. Who are we consulting with, trade unions, etc. Secondly, in terms of the whole structure, yes, they include innovatively climate change, but not in any way that it's part of human rights and environmental due diligence. It's kind of separate and a reporting process for which there could be some director's consequence in remuneration, but it's hard to know how. And there are some innovative things. For example, they have, I think, probably quite a potentially good supervisory mechanism that every single member state would have its own supervisory mechanism, and then it should be clear how the European one pulls them together. And it doesn't make clear that the supervisory mechanism, which I think is a potentially good way forward and follows somewhat what's in the German legislation, it's not quite clear, well, what is their role in terms of clarification of best practices? What is their role in terms of, is their view they take, what does that mean for liability? So I think there's a range of those issues which aren't clear. I think in terms of the general liability, there's a lot of criticisms on that because it's hasn't really taken away many of the obstacles that there are for civil society to bring claims. There are so many obstacles. I mean, I think about the case you were involved in, Penelope, which of course was before Nevson, before the Canadian Supreme Court. Just to get to that stage is an extraordinary kind of element. So I think there's a lot of issues there which I think are difficult, with, as I say, some positives. And I would just mention one potential positive, which is that directors will have duties in relation to this area. And that's new. It was flagged as being going to be a whole push towards improving company law. It hasn't really done that. And what they offer on directors' duties is a little bit limited, but it's a starting point to recognize that one of the ways forward has to push deep into the company before you'll get some action on that. And there are real concerns about, well, what is this scope? Marcus has hinted at this, and I'll let him go back to talk about the concerns there are about the scope of who's covered and what's covered.
Thank you. I mean, we agreed on this little ping pong, but I have to admit, I kind of lost track of the time and the ping pong. So Penelope, can you let us know whether we have already exhausted our time or how much time is left?
You have 3 to 5 minutes left.
Okay, so maybe I can just come back to the scope issue regarding the companies. I mean, and I think someone already pointed out that, of course, counting the numbers of employees is an issue here. What I find actually more difficult to understand is how do you define the risk sectors. I mean, that's something that at least I'm still sort of struggling with, because it talks about obviously manufacture of textiles, leather and related products, wholesale trade of textile clothing and footwear, but it also talks about agriculture, fisheries, forestry, food, beverages. So I mean, it's a little bit, I mean, I think we all have images in our minds what we are actually discussing, and I would agree that there are a number of high risk areas in there, but whether everything that's in there is indeed high risk is something that remains to be discussed. And the reason why I mention that is, I mean, in the past we've seen it specifically, of course, also in the French law, but it's also a debate that we have in Germany and other countries, that if these human rights due diligence laws are not clear enough from the perspective of sort of legal certainty, legal clarity, then constitutional courts or institutions with the power of constitutional oversight will step in and say this is not clear enough, and therefore may actually sort of declare some of these regulations not to be constitutional. I think that's definitely something that needs to be considered. Maybe one last point, because I think from the perspective of the German law, which explicitly excludes civil liability in a very awkward way, it's positive that, of course, this proposal contains the obligation that member states need to incorporate civil liability. It doesn't address all the issues concerning applicable law, jurisdiction, burden of proof, all these sorts of things that we all know about. Obviously, for the technical reason that these aspects in European law are regulated in different regulations, in different legal instruments. So in a way to really assess the whole picture, we would have to wait whether the Commission also proposes some changes to these legal instruments, namely the Brussels 1A and the Rome 2 regulation. And also, I mean, maybe was one last final detail, which is of course something to be discussed as well, is there is a clause in there which suggests that doing due diligence can sort of alleviate from your liability. So it's the due diligence defense, or what's sometimes discussed as the safe haven here. And so that is obviously something that is quite problematic and needs to be discussed and monitored further. And I leave Robert with a final comment.
Okay, my final comment is to talk about the treaty, unless there's anything else you wanted, Marcus. So in this whole other development going on quite separately to what's happening in the European Union is the development of a global treaty on business and human rights. And it came in 2014 after the sense to which the UN guiding principles, we're still very far from actually putting in any kind of concrete legislation. And so it led to a proposal by Ecuador and South Africa to have a treaty, and it's been going on for, I think we must be now up to the 7th session, and it's constantly being debated, and it's moved forward bit by bit. The first few years were discussions, often about an issue which really held up for 2 days, a question: do we include the word transnational companies only, or was it all companies? So all these debates can go on at great length. Just to be clear, we're still quite a long way from this being in place. We've still got a lot of debate to go on. It's got some, I would say, too detailed aspects of it, and it's got some which could have more detail in. I just want to flag one issue in it all, which is that, and it's relevant for the proposal of, what is it, Bill 262, that there's a duty to prevent. And I have to say, I take a little bit of pride in this, because I push very hard for the rewriting to consider, just because it changes expectations. If the duty is on the company to prevent, it changes expectation, in the sense that it also starts with victims' rights and then talks about prevention before it goes on, which I think is possibly a good way to look at some of these issues. So whether or not the European directive, when it comes into play, or even at this stage, will have an impact, hard to know. Certainly the French and the Swiss became much more involved in the discussion once they had laws either in place or about to happen. And the European Union has had a degree of interest in this, and they'll have more. The question is the template of a European-based legislation the right for the global south? And I think that has to be considered quite carefully. And I would also add, Penelope's work in relation to gender issues have been very, very important. Still a long way from perfect, but it's been actually very influential in moving some of those issues forward. So I don't know, I can't say when it'll come to an end or who will end up ratifying it, but it's certainly a process which in my view, has really, really helped two things. Firstly, it's helped a number of states who really haven't been engaged in this to get a little bit of information. And secondly, it's given the global south, particularly the victims of so many of these business activities, having a voice, albeit one not often heard, but it's certainly being said. That's all. Thanks.
Thanks very much, Robert. And I'm glad you mentioned the issue of gender, because I'll just say two things before I pass the floor to Emily. The EC proposal does not actually mention gender at all, which is quite surprising. I mean, it's very surprising to have a treaty that has more progressive language in it than an EU directive, I think, in that regard. So given, who's having to, the broad number of people who are having to negotiate it. So the other thing is, I guess, one of the key things about the treaty is that it really focuses on human rights due diligence and remedy as kind of the core issues. And so it can help to support developments around the world, and vice versa. So I think that's really important point to make. So thank you, Robert and Marcus. And I'm going to now bring us back to Canada and ask Emily if she could, explain to us this model human rights due diligence legislation that the Canadian Network on Corporate Accountability has developed, and the private members bill, Bill 262, that seeks to implement this model legislation, and the importance of having this legislation in place beyond, the forced, the legislation on forced labor that is moving through the Parliament right now. Thanks, Emily.
Thank you. I'm just going to put a couple of links into the chat in case you, like me, are someone who likes to look at things, at words, while you're hearing people talk. The first of those is the executive summary of our model legislation, and the second is a comparative chart of the two private members' bills that are currently before the Canadian House of Commons. One thing that I just wanted to loop back to or add to my interventions at the beginning is that I did skip over existing legislation in Canada. And in part, I did that because the laws that we have on the books either aren't being enforced or aren't adequate to respond. But I just want to name those now because I think it's relevant for this next part of the conversation. So we do, since July 1st of this year, no, July 1st of last year, 2021, have a ban on the import of goods made with forced labor. There's only been one shipment seized, and then that shipment was released. So enforcement, no. We have the Extractive Sector Transparency Measures Act, which requires companies to report on payments to governments. It responds in some ways to information sharing, but doesn't really respond to human rights abuses, obviously. We have a Corruption of Foreign Public Officials Act, the enforcement of which has also been quite dismal. And we have, outside of legislation, we also have a fair amount of efforts to bring claims to Canadian courts through common law. And that has helped advance the debate and the context in Canada quite a bit. So just to say that despite the existing significant barriers to accessing Canadian courts, that work and those efforts to advance lawsuits through common law has really helped move things forward. Two of those cases have led to settlements outside of court. The litigation has led to real precedent-setting decisions. So just to kind of name that. But going back to the specific question that you asked, Penelope, around our model law and the private members bills. So we published on May 31st of 2021, a model law. It was the result of several years of research and engagement with experts, including some who are in the participants and the host here, with our member organizations, and through them, their global partners and directly impacted people and workers. And we also spent a lot of time looking at international best practice, engaging with our European counterparts in particular, because of the major momentum happening towards mandatory human rights and environmental due diligence legislation there, such as in France, the Netherlands, etc. And we had been holding up the EU directive as a model for Canada to catch up to for a long time, and then had to remodel some of our language around that. But the model law that we put forward has three main elements or pillars. First, that companies of all sizes would be required to prevent human rights violations throughout their supply chains. And that is in reference to all human rights and the right, including the right to a healthy, safe, and sustainable environment. Second, that companies would be required to develop, implement, and report on adequate human rights due diligence procedures, including consulting with rights holders throughout that process and setting up emergency alert mechanisms. And third, that those obligations would be enforced and there would be access to remedy for harm through a private right of action to be able to sue companies in Canadian courts if they cause harm, or if they fail to fulfill their obligation to do due diligence. We wanted to make sure that it was very clear that people don't need to wait until harm has occurred before they can try and seek redress. And in addition to that access to courts piece, there would also be the creation of a commissioner to enforce the obligation to report. Included in our legislation, as I mentioned before, it applies to all human rights. We make reference to the major international human rights conventions, the ILO conventions, the UN Declaration on the Rights of Indigenous Peoples, etc. The legislation would apply to companies of all sizes. And the reason that we included that is because in the Canadian context, the vast majority of companies are not big companies. We have a majority of small and medium-sized companies. My time is already up, but I've got a few more things to say, so I'm going to take a couple minutes. And in the context, in particular in Canada, is the fact that we have the majority of the global mining industry is housed here. And some of the, especially those like junior mining and exploration companies, are small sometimes. And so we needed a different thing. So we put in there that the legislation should apply to companies of all sizes, but that through regulation, we would expect that small businesses from low risk sectors would be excluded. The other thing that there's a couple of other things that I want to mention about our model, which is that we included a limited defense of effective due diligence. And I want to explain that, because what it does is it helps to shift the burden of proof. So unlike the French law, where a person is required to establish that the harm they suffered is as a result of the failure of the company to do due diligence, or the failure to implement the vigilance plan. In Canada, if this law was passed, someone who was harmed would have to prove that they were harmed, and that was linked to the company's behavior. And then the company would have to prove that they exercised effective due diligence. They did everything they could to prevent that from happening, but it couldn't. So that's the reason that was included in that way. The other thing that I need to mention about our model is that Canada, unlike European jurisdictions, has a constitutional division of powers, which means that there are provinces and the federal government have jurisdiction over different things. In Canada, harms linked to business activity is very arguably under provincial jurisdiction, which means our model can only apply to the impacts outside of Canada of business activity. That's not because we don't recognize that there's harms or barriers to accountability here in Canada, but just in response to that barrier that we have here, our members are in discussion about how to bridge that gap going forward. So I'm sorry, Penelope, I'm taking more time than I'm allotted, but I'm going to keep going. So our model was taken up by an opposition member of parliament, Peter Julian, tabled in the House of Commons in March, a private member's bill that's based very closely on the model that we put forward. There were some small modifications, but it includes our essential elements. Meanwhile, there's also another private member's bill that has been in Canadian Parliament for a few years, which is a modern slavery reporting law. And I put a chart in the chat that compares the difference between the modern slavery reporting approach and the human rights and accountability approach. S211, which is the modern slavery reporting private members bill, has already gone through the Senate, has come to the House of Commons, and last week was voted on unanimously by members of Parliament. So it has gone to committee. It's the Foreign Affairs Committee who will be studying it. And once it goes through the committee, we'll come back to the House for a final vote. The government of Canada announced tacit support for the modern slavery reporting approach. it said, we're going to vote in support of this law to go to committee, but we're going to ask for some significant amendments. Canada right now, the Canadian government is feeling pressure on forced labor. In the mandate letters of several ministers, there's a commitment by the government of Canada to introduce legislation to eradicate forced labor and to address other human rights abuses. Canada's really falling behind on that piece. The implementation of the forced labor ban hasn't existed, so it's feeling pressure. But we're hoping to encourage Canada not to fall under the trap of modern slavery reporting, given that it's been an utter failure in other jurisdictions, and calling on Canada to catch up to best practice in Europe, and to, if it's going to follow a private member's bill or support one, that it should be C262, which would actually kind of help address the major issues and help ensure that there is access to remedy. So I'll also put in the chat in a moment. To that end, some of our members have put together a sign-on letter for Canadian academics. So any of you who are here who want to add your voice there, you can jump onto it. I could talk about this for another few hours, but thank you very much, Penelope.
No, thank you, Emily. And I'm sorry for putting such pressure on all of you to talk about these very complicated issues in such a short time frame. So I appreciate that you've done such a great job and been all of you so clear in discussing these things. So let me turn now to Daniel and just ask him to, Daniel, can you just give us some insights from how the inter-American human rights system could help to inform legislators in Canada as they hopefully grapple with some of the issues that have been raised here about having, broader human rights due diligence, and how has the, Inter-American Commission on Human Rights dealt with the responsibility of Canada and ETOs? You've already mentioned some of this before, but maybe you want to expand on that. And is human rights due diligence a suitable mechanism for ensuring Canada's compliance with its international human rights obligations? Thanks.
I would start from a diplomatic and political viewpoint. Although, as Emily has mentioned, there has been some progress with regards to other governments. If you remember, for instance, in 2009, when Honduras injured coup d'etat, Stephen Harper was the only head of state in the Americas, eventually one of the few worldwide that did not condemn the coup d'etat in Honduras. And the main reason is because Canada also supported the adoption of new laws. For instance, Honduras enacted a new mining law that hugely favored Canadian mining investments after the coup d'etat. And also in the 90s, in most of the years during the current century, also international development aid coming from Canada helped to shape the legal framework of countries such as Colombia, El Salvador, Guatemala, to favor also foreign investments on the mining sector. Right now, at least, the current government has been very outspoken during political and civil turmoil in countries such as Nicaragua. But there is still, I would say, a double standard in situations such as the increase of mining investments coming from Canadian companies such as B2Gold, Calibre in Nicaragua, after the civil strife that started in 2018. Calibre is a medium-sized company. I think it's based in Vancouver, and it runs 3 mining projects in Nicaragua. And investment has skyrocketed since the beginning of this crisis. So from a political and diplomatic perspective, the adoption of this kind of law would be good for the Canadian image, I would say, in Latin America. From a legal perspective, the inter-American human rights system does not have a specific requirement for adoption of human rights due diligence to address the adverse impact of business activities, but it does rely mostly on mandatory human rights obligations. That's the tenet, I would say, of the inter-American human rights system's legal framework overall. Recent judgment from the Inter-American Court of Human Rights has addressed these issues in countries such as Brazil, in the case of, it's hard to translate that, I have the names in Portuguese and Spanish, but employees of the firework factory in Santo Antônio de Jesus against Brazil. The court requested Brazil to adopt a very specific law to prevent the adverse impact of harmful activities, such as the firework factory. And also a very specific mandate to address the adverse impacts in certain vulnerable populations, such as African descendants and women that were mostly the victims of this case. Also in Honduras, there was a case recently, a judgment recently adopted by the Inter-American Court, in which the court required Honduras to enact a specific law to prevent harm to deep sea fisher activities. The victims of the case were tribal people, the Garifuna people in Honduras. Dozens of them were actually victims of very severe harm. Some of them died, actually passed away due to these activities. And the way in which the Inter-American Court and Commission usually requires states to enact those kind of law, I would say it is in line with a broader law on human rights and due diligence that could be enacted in Canada. And actually, Canada could take a lead on this in the Americas, because unlike European countries, the debate on mandatory human rights law, due diligence law in Latin America and also in Canada and the United States is not that, I would say, advanced. But overall, the legal framework and the jurisprudence of the Inter-American Court and Commission has been relying on mandatory human rights obligation, and one of the ways to implement these obligations are certainly these kind of laws. Finally, it's a matter of time to see a complaint being lodged at the Inter-American Commission against Canada for mining activities of Canadian companies operating in Latin America. There is the HRREC case already under the Canadian jurisdiction. Mariana Barca has been rejected by the Canadian jurisdiction. We can also foresee that could be a complaint filed against Canada to the Inter-American Commission. And even though it takes a long time to have a final merits report, it usually takes no less than 4 or 5 years. I'm pretty sure that the Commission will also require Canada to adopt several basically reform on its legal framework and also policies that could also be tackled through a human rights and due diligence law. And I expect that before that time, Canadian legislators will move forward with this debate and avoid the Inter-American Commission to require it itself. So overall, I think the adoption or enaction of human rights due diligence in Canada could be a very important and significant step to address this issue. As I said, the Inter-American Commission has basically responded to the ETO's claims of Canadian, also Latin American organizations through the hearings against Canada. And many of them actually were performed with the support of the Human Rights Clinic of Ottawa University. So it's a pleasure for me to be here sitting in this event. It will not change. I think there will be also future hearings regarding Canadian mining activities in Latin America, because the situations has been mostly the same, even though the diplomatic debate or the diplomatic speech of the current government has had some improvement compared to the Harper government. But it's also quite obvious that the impact of Canadian mining activities in Latin America has not changed that much. So let's see what the Inter-American Commission will say when new hearings are eventually a divisional complaint is lodged against Canada. So we'll stay here.
Thank you very much, Daniel, for those insights. Very helpful. So I guess we have, say, maybe 7-8 minutes just to have some short interventions from the panelists before we have a short Q&A. So I wondered, first of all, if Robert and Marcus, you could share your thoughts on what Canada could learn from the EU proposal and EU states on human rights due diligence.
Okay, I'll start in a kind of slightly different angle, which Marcus, I'm sure, will be much more precise than I will. So the starting point is, as someone who has a great deal of affection for Canada, I can tell you Canadian reputation is constantly damaged around the world because of its mining companies. And that doesn't help at all in terms of how Canada is seen. And I think that's a reality which could be taken into account in politicians in relation to this area. The second thing I would say is it's very important to get some major corporations on side for this law. That's my experience. I've done a lot of work talking to companies, and it's very important. So it doesn't just seem a civil society action, because that will restrict politicians. Some of the things I've done is get companies up in front of political committees and get them to talk about it. And there are a surprising number of companies who will be supportive of this, but it helps enormously to get them on board. Having said that, I think it's a fabulous draft that you've done. All credit to you. It's very, very difficult to do, I know, from having done these things, and a great credit. In a couple of interesting things, like you've chosen to go with the defense. I'm constantly changing my mind on this. I think for companies, it's a very positive incentive and can be solved that way when you match it with liability. Otherwise, they're nervous of liability. But there's a sense to which maybe the existing laws in your system might well deal with this without it needing to be stated, but I completely understand where it's at. The last kind of general point I'd say, slightly disappointing, but perhaps not surprising in the context, there's no mention of climate change. That is, of course, one of the big issues of our time, and it is really hard. I'm currently involved trying to deal with some of the case law in relation to, well, who are going to bring the claims and how do you prove it? It's not easy. But I think there's a sense to which, if it is going to be tweaked, I would definitely add in something in relation to climate change obligations. So that's kind of an overview rather than a specific element, but hopefully that's of some assistance. So I'll pass you to Marcus.
Thanks, Robert. Marcus, go ahead.
Yes, thank you. Maybe I'll pick up there. I think, I mean, what is apart from sort of the political support that would be helpful if the major companies support this, I think it's also important to maybe try to establish a conversation, maybe even sort of on a more private level, with some of the more like-minded companies on what are their experiences, what do they need, what can they do, what have they done, and sort of what of this could actually be usefully translated into legislation. Because I think there are some good practices out there, and I think it would be important to also take that into consideration. And then even sort of sometimes go into the nitty-gritty little details. I mean, just one footnote of what we've seen in Germany, partly because the whole process was also politically screwed, and it took quite a long time for the political actors actually get their act together. What we have in the law is an exclusion of civil liability based on the law, but that only means that civil liability will be based on the general rules on the laws of conflict. And at the end of the day, it means that many companies will face liability claims based on, you know, the laws of Bangladesh, Nigeria, Pakistan, Brazil, what have you, and will not be able to use the due diligence law as a defense. And I don't think anyone understood that until the very, very end. I tried to say that to the parliamentary committee, but not even the parliamentarians understood that. So be aware of that. You know, sometimes when it gives time pressure, many of these details get lost, and the people in the room and the people on the panel and you all, we are aware of this. But I think it is something that really needs to be explained, not just to the public at large, but also the policymakers, lawmakers at large, and the business community at large. So I think that's something that I would suggest. And the second point is really sort of think of which companies should do what. And I think a big debate we had in Germany was, well, let's not put too much pressure on small and medium enterprises. But of course, it turns out, and this is what small and medium enterprises told us, is at the end of the day, they are required to follow these rules anyway, because they are suppliers to larger companies. So at the end of the day, it may actually make more sense from a business perspective to have it as you do apply to all companies, because at the end of the day, all companies will have to follow it. So those are just two points I wanted to make.
Thank you very much, Marcus. That's also very helpful. So Daniel, do you have any other thoughts that you wanted to add at this point before I ask Emily to respond?
No, just to mention that besides the Inter-American Human Rights Systems, Canada has been also object of pronouncement of several UN organs, such as the Working Group on Business and Human Rights, also different committees. And once again, I think that Canada is the main, I would say, client of ETO's pronouncements of the inter-American human rights system, and also the UN human rights systems. Penelope is the expert here in this table. Who am I to teach you about this? But as long as the current legal framework and policies in Canada has no significant change, it will keep being one of the I would say the bad actors on for those international human rights systems. And we'll see again and again new reports and pronouncements condemning Canada for basically washing its hand when its companies violate human rights abroad. That's my last thought.
Thank you very much, Daniel. Yes, this idea too that there's a huge reputational issue here, in addition to the moral and legal issue as well. So, Emily, can I ask you to, for your thoughts, just with the last word here before we go to the Q&A?
Yeah, no, I think this has been a really invigorating discussion, and I think that those suggestions are all great. I'll kind of pick up on two of them, which is kind of engagement with business actors and climate change. So the CNCA is quite small. We're like 2 and a little bit staff people. So we have to make some choices about what we're able to focus on. And our experience in campaigning on these issues, we put a lot of energy into engaging with the mining industry on our ombudsperson campaign. For example, saying we've included all of these procedural protections. What more would you like to see to feel comfortable? And couldn't get a straight answer to those questions. But one of the things that we do see as an opportunity right now with human rights and environmental due diligence legislation is that it doesn't only apply to the mining sector, which means there are businesses who from other, and we're already seeing some in private spaces who are more amenable. And also given the fact that despite the lobbying in Europe, there's also a lot of European companies who've been out in the forefront, and some of those multinationals also have Canadian wings. So we do see some opportunities there. Some of our members and allies who we work with are doing some of that engagement, but we haven't seen it yet. But also in the Government of Canada's supply chain legislation consultations that happened in 2019, and the report from that came out just a month or two ago, they did say that the majority of companies who they talked to weren't opposed to due diligence legislation. So that's at least something. On the question of climate change, we have one of the things that you'll see in our model law is that we put in a footnote. I can't remember where we said we're going to adapt this later on. We're putting this out as a best practice, but saying it's good. We recognize it to be a living document that may need to be updated. And so climate change is one of those pieces that we are, one of our members commissioned some research to understand exactly how the existing model could be used for climate change cases, even if it wasn't changed, around kind of the right to a healthy, sustainable environment, but then also looking at engaging with the Climate Action Network in Canada and others to see about potential changes going forward. Because I think also what happened at the European Union, I think was a little bit of a surprise that was included in that way too. At least it came as a surprise to us. We said, oh, we'll try and latch on to that. But yeah, but very good points. Thank you.
Thank you very much, Emily. So we've got a few questions in the chat here, and I'm just going to go in order in which they came in. Sofia Caro de Nuto has asked whether or not Canada is considering specific legislation to regulate imported wood that has been, I guess, from created by deforestation, like the EU's proposed regulation to minimize EU-driven deforestation. Now, I haven't heard of it, but I don't know if Emily, if you've heard of something like that. I don't think
I've
We
not
have
heard
that.
any rumblings at all, no.
No, okay, so so the other one question, I guess, would be for Marcus and for Robert. It says, does the number, talking about the European proposal, does the number of employees encompass the whole of the company, including like subsidiaries, or is it just the parent company?
I think, I mean, but Robert, please correct me if I'm wrong. I think that is not entirely clear from what I can see, and at least it's been a criticism by some observers that needs to be clarified how that is actually counted. But maybe Robert, you know more about this.
Only that under the French law, they have a slightly different
Yes.
numbers, whether or not it includes the overseas employees or not. So I suspect that's what they intended, but it's not, it would need to be clearer.
Yes, that's true. And in German law, it's also mentioned what is counted and what is not counted. So, and I guess that's the takeaway from these two laws. If you rely on employees, you need to be very precise on who you count and who you don't count.
Thank you. Another question that's come from Lena Lorenzi Escobar is, I guess this is the second question from her, is that whether there's any discussion, and I guess we could open this up to Europe, European countries, Latin American countries, and Canada, on human rights due diligence requirements for listing on stock exchanges. So specifically, she says the Toronto Stock Exchange, but I guess I wondered if that sort of was something that was available in other countries or the European
I can
Union.
answer that to the extent that it has been discussed, even in countries such as Singapore and Hong Kong. So it is being discussed. It's not, I mean, the SEC in the US has raised this as a part of what they call sustainability activities. I'm not aware of any which has yet made it a requirement in stock exchange listing, but I think it's quite a potential way forward on this area, but I'm not aware of any that have gone that far.
Emily, I don't think that's part of what's being considered in Canada. It's no. Okay, Daniel, do you know of anything in Latin America?
No.
So no, I mean, it's, you know, the thing about human rights due diligence laws, they start off as pretty narrow, and I think there's a potential, you know, once you get them in place, to then expand legislation that would cover some of these other issues and have different trigger points to incentivize companies to, you know, take preventative measures with respect to their human rights and environmental impacts. So I can't see any other questions. Does somebody? Oh, so here's one. Does any other country outside of Europe have a human rights law? I'm assuming human rights due diligence law in place that applies to, you know, companies that are registered in that country that are operating abroad. And I'm not aware of anybody.
Okay,
you know
I think what Ruth might be asking is, is there a situation where a state is applying its law to a company registered outside that country? And I'm sorry if I misunderstood that. So that, is it possible, say, for Germany to pass a law which deals with a German subsidiary which is registered, let's say, in Burkina Faso? The answer is yes, that's what they are doing, except they're not doing it. It's this classic thing. They can't directly apply law to Burkina Faso because that would be a broader issue of breach of sovereignty and jurisdictional issues. But what they're doing is applying the law to the parent company. And if that parent company has subsidiaries which are registered elsewhere, they're reporting back to this, in my example, the German law, because German law can apply to a German company. So that's what I'm guessing Ruth is asking. I'm sorry if I've misunderstood your question, but that's a very common concern because, you know, is it right that you're applying to a company which is registered elsewhere? But because the sneaky thing you're doing is they're not directly applying it to a company registered elsewhere.
Right. Thank you. Emily, did you have anything to say about that? Or anybody else? Okay, there's another question from Kernahan Webb. Hi, Kernahan. Thanks for joining us. Do any or all of these laws acknowledge or otherwise encourage complainants to first of all use the legal system of the countries where the harm has taken place, or can they hop directly to a northern court system? And he says, I note, for example, that many Latin American countries and not many northern countries have ratified ILO 169, protecting indigenous communities, which would in some cases make their legal system preferable. I realize that there are corruption problems, but using the local legal system is a good way of getting improvements in the legal system. Yeah, Emily.
I think this is an important question, and that's not a requirement in our model, nor do we think it should be. It's well established in UN norms that people should have access to effective remedy, both in their home, in the host states where companies are operating, and in home states. And sometimes who you're holding accountable will be like, there's nothing to say that you can't have a lawsuit happening in Guatemala, a criminal suit against someone who's involved in killings or rape, and also have a civil suit in Canadian courts against the company who's profiting off of that abuse. And I'm using that example because it exists right now, that there are criminal lawsuits in a Guatemalan case involving a Canadian company. So I think that that paradigm, or that distinction of saying it's either or, isn't actually adequate. What we need is both. What we have right now is an almost complete accountability gap, where people can't access remedy where the harm is happening. People can't hold the parent companies accountable, and our international systems aren't set up for remedy either. And so we should be looking to strengthen all three of them, not putting in that kind of requirement that would be an additional barrier to accessing remedy.
Yeah, I would agree. Oh, sorry, go ahead.
Go ahead, Robert. To what Emily said, with which I agree, which is, unfortunately, some courts, and sometimes it used to be the case in Canadian courts, used to be even further go the case in UK courts, and is not the case at all across civil European continental cases, that there was this idea of forum non-convenience, the sense to which it isn't the right forum. You're suing in, let's say, Canada, you should be suing back in Guatemala. That was the position. The Canadian courts have slowly moved that way. And sadly enough, the US courts are still very frequently using it. So that can be a real barrier for bringing an action in a court, which is, as you say, the home state. I can just add a warning on that. I was involved in one of the big cases before the UK Supreme Court called Vedanta and Longawi, and also Okpapi and Shell. And in the first instance, the court worried whether or not it should have really been held in Zambia, because the Zambian government, put in an amicus saying it should be in Zambia. What are you doing, you kind of colonialists trying to do this? And the court went through a lot of agony to say, well, they still can't get a remedy there, and they've asked for the remedy here. That's what we should give them. It didn't go so far. They just said, we've got jurisdiction. And I know the Zambian lawyers were pretty cross. They said, how dare this court, in an imperial way, make a decision in relation to our own system. Except the reality can often be very difficult, not only for the victims, but the companies can often use international investment law to try and get out of that company's jurisdiction. So it's often not clear cut, though I share Emily's broader view.
Yeah, and I would say I agree with that they need, if we leave the choice to the victims about where they want to bring the case, because there are, and Daniel, perhaps you can say a few words about this, there's a lot of cases that are being brought in Latin American courts, right, that make their way sometimes up to the human rights, the inter-American human rights system against companies about business activity, are there not?
Yeah, that's for sure. I would say that for the sake of fairness, companies usually can employ the foreign shopping strategy. They can sue a country, actually the victims themselves, in several jurisdictions. And victims, they basically can try courts in countries such as Guatemala, that right now the general attorney has just been reappointed. And she has basically persecuted most of the judges and prosecutors who were investigating sensitive cases relating to corruption that involve both the political and economic life. Well, yes, it would be great with countries such as Guatemala that ratified ILO Convention 169 could apply the standards set forth in this kind of convention, but in the practice, companies can deal with this kind of complaints in their way. And for instance, a few years ago, the Guatemalan Constitutional Court halted a mining company run by Canadian, like one of the most important Canadian mining companies in San Rafael Las Flores. And the rapporteur of the person who led this decision need to flee the country because she was persecuted by the Guatemalan Congress. So in this vein, I do agree with you, and I will take the last word of Penelope. Victims should have the option to employ the jurisdiction in their reach, because companies in the end has a much broader access to several jurisdictions, and eventually also investment panels in the World Bank and elsewhere to demand countries with a compensation of, I don't know, $300 million. With luckily a victim of a case such as this one in San Rafael Las Flores, the Xinca people, if they reach the Inter-American Court of Human Rights, the reparations or compensation will be no more than $50,000. And that's the difference between the teeth of the Inter-American rights system and the teeth of those kind of panels. So for the sake of fairness, I do believe that the best, I would say, policy would be to leave for the victims the options to employ one of other jurisdictions.
Okay, so if I could just ask you, there's one last question that we have, and it seems like a good one to kind of end this on. So if you could bear with me, because I know we're right at the time limit, which is 1 o'clock. Is that okay? Everybody okay for 3 or 4 more minutes? Okay, thank you. So Hector Candre has asked us, it seems that the mandatory human rights due diligence laws are high leverage for change and possibly for the good. In applying to supply chains, can they be far-reaching and affect companies and peoples in other states? And do you know any study that would be useful that, to help them understand how far-reaching the enacted laws are? Anybody?
I'll bravely start by saying it's a great question. And of course, we're still at an early stage. I mean, I think it'll be very hard to have such a study, and I've done lots of empirical work, because we haven't yet had the laws in place to know. All I can say out of the limited experience of some of the laws that have been in place a while, like the French duty of vigilance law, which is that the evidence is that companies are beginning to respond to it. Initially no, and then they're beginning to respond to it. The other evidence goes the other way and fits in with something Emily held further, that where it's only a reporting requirement, and often they're not really due diligence laws, but often it's an only reporting requirement, such as the UK Modern Slavery Act, the evidence is companies don't do much about it. Why? Because there's no real incentive in terms of sanctions. But Marcus might be correctly to say there's a better study than I know of.
Marcus.
No, there's certainly no better study, but I just wanted to point out, when we look at the empirical evidence, I mean, of course, we need to look into what's happening on the ground, but we should also be looking at what's happening inside of companies, and at least which anecdotal evidence suggests that once you have binding legislation, the responsibilities within the company, within the board, within the management changes from sort of who is in charge of what, and empowers those in companies who are actually sort of wanting to do some change. And I think that's also at least one side of the reality, which we also should be looking at.
Anybody else have any comments? Yeah, Daniel? No? Okay. Okay. All right. So I think we will wrap up there. I just want to, first of all, start by thanking our panelists, Emily, Daniel, Marcus, and Robert, very much for taking the time to share your expertise about these issues. It really was a very interesting and informative discussion, and I appreciate it very helping me to launch the speaker series with such a great event. So thank you very much. I want to thank again Caroline and Viviana at the Human Rights Research and Education Center, Jake, Rochelle, and Bahar for helping me prepare and to everybody who participated as well, and for the great questions that I think have really added to the discussion that we had. So thank you very much, everybody. And I hope you enjoy, Marcus and Robert, the rest of your evenings, and Daniel and Emily, the rest of your afternoons. Thanks so much.
And thank you so much for hosting it and bringing us all together.
Thanks. Thanks, everybody.